Welcome back. So today I'll be talking about the Little Rock Nine. You can't keep black phoenixes down. But first, let me go back in time. During the Reconstruction era, the period right after the Civil War that ended slavery, Congress passed 3 amendments to the Constitution, 13, 14, 15, to secure political rights for black people. Additionally, the U.S. Congress, aka the federal government, directly addressed racial discrimination against African Americans by the passing of the Civil Rights Act of 1875. The Civil Rights Act of 1875 recorded, quote, the full and equal enjoyment of any of the accommodation, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, subject only to the conditions and limitations established by law, and applicable alike to the citizens of every race and color, end quote. However, in 1883, the U.S. Supreme Court struck down the Civil Rights Act of 1875, holding that the 14th Amendment does not give Congress the right to prevent discrimination by private individuals. Private discrimination was regarded as being within the jurisdiction of the states. At the same time, states were creating laws to ensure legal racial inequality, including requiring that children attend separate schools according to race. These Jim Crow segregation rules were even applied to interstate travel. Of course, black people such as Ida B. Wells Barnett pushed back against the segregation laws. Other resistors was a group of young black men from New Orleans called the Citizen Committee, who in 1891 attempted to test the constitutionality of the separate car law as it pertained to interstate travel on the railway. After some good fortune in the court with their lawyer Albion W. Tourguet, the group decided to have a test case which would become one of the well-known civil rights cases, Plessy v. Ferguson. Quote, with the corporation of the East Louisiana Railroad on June 7, 1892, Homer Plessy, a mixed-race man, 7/8 white, so he's more white looking than black, seated himself in a white compartment, was challenged by the conductor, and was arrested and charged with violating the state law. In the criminal district court for the parish of Orleans, Tourguet argued that the law requiring, quote, separate but equal accommodations, end quote, was unconstitutional. They lost in the U.S. Supreme Court, where it was held that separate but equal would remain the law. But separate was never equal, as white people were always given more resources than black people, but black people kept resisting. In the 1950s, segregation continued, and a black family took up the mantle in the case of Brown v. Board of Education of Topeka, 1954. The Brown family lived in Topeka, Kansas, near a whites-only school. However, every day, Linda Brown and her sister had to walk through a dangerous railroad yard to the bus stop to attend their all-black elementary school elsewhere. Linda and her family believed that segregated schools violated their 14th Amendment rights and sued the Board of Education. The Brown family lost in the federal district court, where it was held that those segregated schools were harmful to black children. It was legal because both school systems had similar elements like teachers' desks and chair. So this government knew something was harmful to kids, but they were still going to do it. The Browns appealed and won in the U.S. Supreme Court, where it was unanimously ruled that separate but equal violated the 14th Amendment of the U.S. Constitution. Quote, we conclude that the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Chief Justice Earl Warren, writing for a unanimous court. Sounds great, right? All's well that ends well? Nah. This is America that Childish Gambino sings about. Laws are great, but enforcing the law is another matter. In 1957, 3 years after the Brown v. Board of Education ruling, the district superintendent of Little Rock School District, Virgil Blossom decided that he would gradually integrate the schools by inviting volunteers from the two all-black schools, Dunbar Junior High and Horace Mann High School, to attend the all-white Central High School. The black students who wished to attend wanted to be there because the school had more resources. However, as one of the Little Rock Nine said, the black students were told that they would have only limited access to those resources. Charlotta Wallace Lanier said, quote, Blossom said, you're not going to be able to go to the football games or basketball games. You're not going to be able to participate in the choir or drama club or be on the track team. You can't go to the prom. There were more cannots. I won't waste your time or stress my delicate throat to tell you about all the awful things that were done to those 9 black children, even when President Eisenhower sent troops to ensure the laws were enforced and the children kept safe. Nope. What I'm here to tell you about is that they can't keep black phoenixes down, so please permit me to read the biographies of the Little Rock Nine posted on the National Services website to prove my point. But I'm going to stop here just in case you've listened to all you can listen to and put their biographies in another video. Thanks so much for listening.